All right, deep divers, welcome back. Today, we're not just dipping our toes, we're diving headfirst into the Manual of Patent Examining Procedure, the MPEP. Think of it as the ultimate operating manual for navigating U.S. patent law, and it's something we're exploring section by section in this series. Our mission today is to crack open Chapter 200. That's types and status of application, benefit and priority claims, and specifically MPAP Section 201, types of applications. This section really it lays the absolute foundation. We're talking about the different doorways inventors can use to protect their ideas. And, by the end of this deep dive, you'll have a clear, accessible, and hopefully strategic understanding of these crucial entry points.
Absolutely, and this section truly is the bedrock. I mean, before we can navigate the more intricate strategies in patent practice, we have to understand these fundamental categories of applications. It's not just about memorizing definitions, like you said. It's about grasping the very architecture of the patent system and the strategic choices an applicant makes right from day one. This deep dive should really illuminate how each type serves a distinct purpose, connecting the dots so you can see the bigger picture of how an invention moves from concept to, well, protected intellectual property.
Okay, so let's open the first few doors then. The MPEP identifies three primary types of patent applications, each for a very specific kind of invention. And the one most people probably picture when they hear patent, that's the utility patent, right?
That's the one, yeah. Utility applications are the broadest category, kind of the workhorse of the patent system. They're designed to protect how an invention works or, what it does. We're talking about everything from new processes, like a new way to manufacture something, to machines, manufactured articles, compositions of matter, and even improvements on existing ones. So if your invention has a functional aspect, this is likely your pathway. The key takeaway for you, the inventor, is that a utility patent aims to protect the functional essence. Think the engine inside a car or the software running an app, that sort of thing.
Got it. But not all innovation fits that mold, does it?
Right.
What about, say, the botanist who breeds a new, unique rose? Or a farmer who develops a hardier wheat variety? That's where we step into the specialized world of plant patent applications.
Precisely.
Mhm.
Yeah, plant patents are a fascinating and really distinct category. They're specifically for new and distinct varieties of asexually reproduced plants. That means plants created through methods like cuttings or grafting, basically where the offspring is genetically identical to the parent.
Yeah.
So we're talking about unique hybrids or mutants, maybe a new type of fruit tree that yields larger produce or a flower with a completely new color combination. It's about protecting that botanical innovation that's been cultivated and can be, reliably replicated. It ensures those unique agricultural and horticultural efforts get protection.
Okay, interesting. And then rounding out our big three, we have a type of patent that ignores function entirely and focuses purely on aesthetics, design applications.
That's right. Design applications protect the look of an article, not its function. We're looking for a new, original, and ornamental design for a manufactured article. So think about the distinctive curve of a new smartphone, or maybe the unique tread pattern on a tire, or even the visual interface of a computer icon. The crucial distinction here is, like you said, utility protects how it works. Design protects what it looks like. It's a really powerful tool for brands to protect their visual identity. And what's particularly relevant for, a global marketplace is that these design applications can be filed internationally under the Hague Agreement, that's an international treaty, and that can secure U.S. protection, streamlining how companies protect aesthetics across borders.
Right, the Hague Agreement. Okay, so we've identified the big picture goals, protect a machine, a plant, or a unique look. But once you decide on the type of patent, how do you actually file for it here in the U.S.? That's where the framework for national applications comes in under Title 35, Section 111, giving us different pathways.
Indeed. Yeah, when we talk about national applications, the first major split is between non-provisional and provisional applications. A non-provisional application is what most people think of as a full patent application. It's the complete package. It requires a detailed specification, at least one claim defining the invention's legal boundaries, and usually drawings. These are the applications that get examined by the USPTO, the Patent Office, and can, if successful, mature directly into an issued patent. It's the full commitment, really, intended for serious examination.
Okay. And then there's the provisional application. It sounds like a shortcut, maybe. But what's the real trade-off? What does an inventor need to weigh if they go that route?
That's a fantastic question, because the provisional application is a powerful strategic tool, but it comes with a critical caveat. Its primary purpose is to let inventors secure an early filing date with fewer formalities and, importantly, lower initial cost. This means you only need a written description and any necessary drawings. Critically, no claims or formal oath are required at this stage.
Ah,
So the real insight here isn't just that it's a placeholder. It's more that it's a cost-effective gambit. Imagine a startup, right? They have a promising prototype, but maybe limited funds.
hmm.
A provisional application lets them lock in an early priority date for their core idea pretty cheaply. They then have a full year, exactly 12 months, to refine the invention, do market research, maybe secure funding, find partners, before they have to commit to the significant expense and detail of the full non-provisional application.
So it's buying time.
Exactly. Buying
Right.
time and legal protections strategically.
Hmm.
However, and this is crucial, the 12-month clock is absolute. A provisional cannot mature into a patent on its own. It must be followed by a proper non-provisional filing within that 12-month window, or you lose that priority date, it just expires.
That's a really crucial distinction. It's like a temporary reservation for your idea then. Okay, but patenting isn't always a straight line, right? What happens if your invention evolves or the patent office, throws a curveball? The MPE details specialized national application types that let inventors adapt their strategy.
Yes, these specialized applications are truly vital tools for maintaining continuity and adjusting the scope of protection as things develop or during examination. First, we have divisional applications. Think of it this way. Sometimes an inventor files an application that actually describes two or more separate inventions.
Right.
If the patent office agrees, they might require you to basically split it up. It's called a restriction requirement. A divisional application is then carved out of that earlier filing. It lets each distinct invention be pursued separately. It just ensures that each unique inventive concept gets its own proper examination.
Ah, okay. So you don't lose the chance to protect everything just because it was initially filed together. Makes sense. What about if you want to keep pursuing the same invention, but maybe with slightly different claims?
That's exactly where continuation applications come in. These applications essentially repeat the disclosure of the description and drawings of a prior filing, but they seek additional or different claims. And the brilliance here is that you maintain the benefit of that original filing date for the common subject matter.
Oh, that's key.
It is. Why do this? Well, maybe after the first round of examination, the inventor realizes their initial claims were too narrow. Or maybe new prior art popped up. Or they simply want to pursue broader protection. A continuation lets them adjust their claiming strategy without losing their place in line, so to speak, for the underlying invention.
That's incredibly flexible. And then there's a third type in this strategic family, one that allows for even more evolution.
Indeed. That would be the continuation in part, or CIP, application. These are unique because they allow an inventor to add new subject matter to the original disclosure, while still claiming priority to the earlier filing for the common overlapping subject matter.
Okay, so part old, part new.
Exactly. This is really useful when an inventor develops significant improvements or new aspects of their invention after the initial filing, but before the patent is granted. For the new stuff, the filing date is the CIP's filing date. For the old stuff, you keep the benefit of the earlier date. So each of these types, divisional, continuation CIP, serves a specific strategic purpose, preserving rights, adjusting scope. They are, frankly, indispensable tools for inventors to refine and adapt their strategy over time. Makes the system more agile.
So we've covered the main domestic pathways, lots of tactical flexibility there. But what if your invention has global potential? Innovation doesn't stop at borders, obviously. The MPP also acknowledges and distinguishes these national filings from international applications.
That's right. And for inventions with global reach, the Patent Cooperation Treaty, or PCT, applications are a crucial mechanism. The PCT is another international treaty. It lets an inventor file a single international application, which can then designate a multitude of countries, including the United States.
Okay.
This single filing basically acts as a placeholder in all those designated countries. It gives you more time, typically 18 to 30 months from your initial filing date, before you have to commit to the expensive process of filing individual national applications in each country.
Right, that delay can be really valuable.
Absolutely. When a PCT application designates the U.S., it eventually enters the national stage for examination here. It's examined much like a domestic application, though there are some unique procedural differences, like how they handle unity of invention. But the main benefit for you, the inventor, is vastly streamlining that initial filing process across many countries. Saves a lot of hassle and upfront cost.
And just like utility inventions, design applications also have an international pathway, you mentioned.
They do. Yes, as we touched on earlier. For international design protection, the Hague Agreement system is key. This system allows for the international registration of industrial designs. It simplifies the process for protecting the ornamental look of products in numerous member countries.
Mm,
So if you have a visually striking product you want to protect globally, the Hague system offers a centralized way to do that. And you can designate the U.S. for protection through this route. Both these mechanisms, PCT and Hague, are critical for coordinating patent and design protection efficiently across borders.
okay. Now, patent law, like any specialized field, it has its own very precise vocabulary. MPP Section 201 also takes time to define some key terms that pop up frequently. Understanding these is crucial for clarity, right? Especially about an application's history.
Absolutely. Let's clarify a few terms that can sometimes cause confusion. First, an original application. This term simply refers to any filing that is not a reissue application. It just sets a baseline, indicating the application's starting point, or maybe a fresh line of examination, could be the very first filing, or a subsequent continuing application that properly maintains priority.
Okay, and then there's substitute application. This one sounds a bit like a continuation, but you said there's a critical difference.
You're spot on. A substitute application is essentially a duplicate of a previously abandoned filing. The crucial distinction here for an inventor listening is that unlike other continuing applications, a substitute application does not get the benefit of the earlier filing date of the abandoned application.
Ah, no priority claim.
Exactly. It's treated as a fresh start, a completely new application. And this is critical because, as you know, your filing date can have huge implications for patentability, especially against prior art.
Right. And that leads us nicely to continuing applications, which, in contrast, do get the benefit of an earlier filing date, if done correctly.
Precisely. Continuing applications that family, including continuations, divisionals, and CIPs we discussed, can claim the benefit of priority to earlier filings, which is a significant advantage. It lets inventors keep that crucial effective filing date of their initial work. But this benefit isn't automatic. It's only granted if they comply with specific legal requirements. Those are laid out in the law in 35 U.S.C. Section 120 and 121 and some related rules. These distinctions, original, substitute, continuating, they matter deeply because they directly affect the scope of protection, your effective filing date against prior art, the continuity of examination, all critical to the patent's ultimate value. You know, the beauty of MPP Section 201 really is how it functions as this foundational structural map for the whole patent system. It's not just a dry list of application types. It's really a guide to the key legal rules governing them. And importantly, the strategic choices applicants can make throughout the process. Understanding this section really empowers you to see the options available right from the start.
Yeah, it's like getting the legend for a complex map. It gives you that immediate understanding of the terrain. By grounding patent practice in these clear definitions and strategic options, this section serves as an essential reference point for all the subsequent rules on status, priority, benefit claims throughout Chapter 200, which, we'll keep exploring in future deep dives. It truly is the starting block for anyone serious about navigating U.S. patent law. And that brings us to the end of another, hopefully enlightening deep dive into the MPEP. We've navigated the crucial categories: utility, plant, and design patents. We've untangled the strategic differences between provisional and non-provisional filings, explored tactical tools like continuation and divisional applications, and glimpsed the international pathways through PCT and Hague. We've also tried to demystify some key terminology that underpins the entire patent system, helping you understand that foundational map of patent applications.
Yeah, and I think this deep dive into MPP Section 201 really highlights a fundamental truth about IP. Successfully navigating the patent system isn't just about having a brilliant invention. It's really about making informed strategic choices from the very first filing. You should consider how that initial choice of application to, provisional, secure an early date and buy time, utility for function, design for looks, how that choice can profoundly impact the entire trajectory and ultimate value of your intellectual property down the road. The system offers incredible flexibility, but with that flexibility comes the critical responsibility, really, of understanding which pathway best serves your specific inventive vision and your long-term goals.
Well said. And on that note, we'd like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
And just a reminder, this summary of the MPEP was generated using AI tools and may contain errors or omissions. It's provided for general educational and informational purposes only. It is definitely not legal advice or a substitute for formal instruction. For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.